Hey, this is Bill Gross, the LA probate expert, with an interview with Mark Swatik, who's an attorney who does estate planning, and we'll talk about that in detail. As you know, I'm always on the subject of avoiding probate where you can. I'm the one who helps you if you're stuck in probate as a real estate agent, and Mark is one of the attorneys we work with to help our customers avoid that. So, Mark, welcome to our call.
Thanks for having me, Bill. Excited to be here. Excited to help.
So, tell us a little background. Were you born, grow up, go to school? And then how'd you get into law?
Oh, good question. So, born in Chicago, Illinois. Parents were in medicine there and enjoyed Chicago for a short period. Still remember the freezing winters. And ultimately, we relocated initially to Arizona, then ultimately to California. Grew up in California, high school, and have been here ever since.
Well,
And I've now, yes, certainly vowed never to go back to Chicago to live.
where'd you go to high school?
At Miracosta.
Miracosta, big high school. And where you go to college and where you go to law school?
So college, ultimately, I had an undergraduate program, Long Beach State. I had a master's degree in business administration from Webster
Nice,
University. And
nice,
then law school was at William Howard Taft in Orange County.
very nice. So what prompted you to get into law? How'd you go from college to being an attorney?
Well, that's a great question. So I was working as a police officer, hired when I was 20 years old. And I enjoyed that. My parents were a little ambivalent, as you can imagine, about working for a police department and then working in a very busy area, Hawthorne Police.
Ooh,
Yep, and saw quite a bit and ultimately realized within a short period I needed to educate myself. The police department had a terrific program to supplement tuition and reimbursement for costs and related expenses. So that was a great start. And then they incentivize you to continue through graduate school. And then law school, funny enough, I was afforded an opportunity to throw my name in the hat for a scholarship afforded to a police officer in the United States for law school.
wow.
And it was a very competitive selection process. Ironically, I couldn't win $5 in the lottery if I put all my effort into it. But strangely enough, I succeeded in that selection process,
Wow.
chosen for the scholarship. And that helped quite a bit because my MBA program cost me, boy, nearly 90,000. Another couple 100,000 for law school would have been unreasonable. So
Wow.
that's how it came about.
Uh, I don't know if I mentioned my father was an attorney in the city of Whittier for years when I grew up, and then he's since passed. But he had a partnership with two other partners, and then they brought in a fourth partner to handle criminal law, who was not a policeman but a sheriff, similar. I think Whittier is served by LA County sheriffs, or it was at the time. Who similar story. He was a sheriff, and they subsidized education, and he ended up going to law school I think at nighttime and became a partner of my father. So it's an interesting track. Now he went criminal law, and you didn't. That's an interesting choice. How did you end up in estate planning and avoiding probate and those kinds of things?
So that's actually a great question. I had really exceptional mentors growing up, one of whom happened to be a Superior Court judge, an
Wow.
exceptional man. And he had been a police officer. And he
Wow.
decided to go to law school as a police officer, passed the bar, became a deputy district attorney, and then
Wow.
appointed to the bench. And he was helping me in so many regards. And there was a natural presumption that since we had nearly identical career paths, I would follow in his footsteps. But I told him I loved my police career. After 20 years, I had a great
I can
time,
hear
but
it coming. I can hear it coming.
no, I just was, everyone presumed, and rightfully so, I would just gravitate naturally into criminal prosecution with a law enforcement background.
Mhm.
And I thought that would have been very interesting and enjoyable, but I was just ready for a change. So I asked my friend, the judge mentor, his thoughts about estate planning. And he said, interestingly enough, I have two brothers, also attorneys, who have been in the estate planning arena for a long time, and I'll make an introduction. So the introduction came, and we had a great initial meeting. There was no job opportunity for me initially, but they were nice enough to say they would mentor and help me along. So I joined a different law firm and progressed well there. And they were still helping me throughout that process. And then I was invited to join them in 2015 as a partner. And the rest has been history. So it was flatly, if I can share very briefly without boring you here, we had a police officer, the first in the history of the entire department, to be killed in an automobile collision. And that was obviously tragic. He was survived by a wife and children and had many complications as the result of this untimely passing. So I used that as an opportunity to educate. And so I started teaching and explaining, especially for people in public safety. They had a higher mortality rate than most, and they voluntarily chose this profession. So I informed them there was somewhat of a duty to protect themselves and their families.
Right.
A lot of people understood it, and the gravity of losing someone in your police family obviously makes an impression. With that in mind, we started helping and moving in an estate planning direction. Literally 2 years later, we had a second officer killed, and it was remarkable. He was a terrific person, and he had told me after seeing my educational seminars, this is why I commend you for doing this, because people don't know these rules and we want to teach them and help them. But he vowed to have it done. He had other priorities, as most people do, and tragedy struck. We had to probate his estate and things we could have avoided. So it's still helping people, the estate planning concept, like I did in law enforcement, but now in just a different direction.
Wow. So let's pivot a little bit and talk about probate, which is my specialty, but really your whole business is about avoiding probate for the most part, or I should say a substantial piece of it. So one of my friends describes probate as when you die, filing a lawsuit against your own estate and eating up the equity left for your heirs. Does that sound about right to you?
That's an interesting concept. So as a concept in regards to probate and how it applies, yes, are we undergoing a court proceeding analogous to a lawsuit? And yes, are we ultimately losing money and wasting time, like could happen in a lawsuit? So I understand that parallel. Of course, we prefer to avoid losing money and losing time. And then commonly people are in conflict when money is involved following the death of a loved one.
Yeah, that's the thing. So the other thing I've discovered in my experience here in probate real estate is the biggest misconception that I get probably weekly is I don't need to worry about a living trust. I have a will. So, and I try to describe, well, there's a piece of the will that goes in your living trust package, your estate planning package, but that a will is worthless until it's probated in court. Does that sound about right to you? Or how do you describe that process?
No, I like that. So is it worthless? No, I just tell people that a will does take legal effect when a person expires, but it offers no privileges, no protections prior to passing away.
But it also needs to go to court to be put in effect.
Yes, sir. Excellent. So, of course, once we have a will in place, people also fail to recognize that a will shall be probated. Probably the number one misconception. I hear all the time, Mark, I have a will, I'm covered. I tell them, hold on a minute. As long as you understand the ramifications of that, loss of time, money, and mandatory probate, are you sure you want to take that route? Everyone says, what do you mean? Or I never want that. And I say, well, hold on a minute. We better have a different discussion. So good point there. Yes, we have to be careful with that.
And people who need to, in my mind, I'm not from a legal opinion, but just from a business point of view, I can say should have a living trust or program put together ahead of time. If you have more than $167,000 of assets, not counting your life insurance, not counting your retirement funds, but bank accounts and such, or real estate or other personal property, that has to be probated for full probate, is one reason why you might do it, right? And if you have less than that, there's a streamlined process, but if you have more than that, unless you have a living trust, doesn't matter how good your will is, doesn't matter how clear it is, 1 heir, 2 heirs, 50 heirs, you're giving it all the way to charity, if you have more than that amount of money, you're going to go to probate court to effectuate the will, correct?
You sure are. Lots of facets to that. I don't want to really get into the weeds and bore people, but bottom line is people say a couple of things. I'm below the threshold, presumably. Ultimately, they think because they have a beneficiary form on file, the common rule there is that you will avoid probate with a beneficiary form, and you can have an indefinite number for that account. It can exceed 166,000 100 times. As long as there's a corresponding beneficiary form, it always avoids probate. Provided, the caveat there is that the intended recipient is alive. If the beneficiary, yes, sir, is unfortunately predeceased, the owner of the account, there's an automatic reversion back to the account of the decedent. And people say, wait a minute, we had a bank account, had a corresponding beneficiary form, no probate. Yes, provided. And then the other factor, which I hate, but happens frequently, is you'll find that the beneficiary form is misplaced. The financial institution lost it. They took Swatik's beneficiary form and put it into Swamper. And who knew? Bottom line is, it's not there, it can't be located, and the bank is unforgiving in that regard, and they don't have a choice. Typically, we have to go through probate.
Right.
So we have to be careful with these nuances.
So banks, which will basically be hacked every day almost by Russian hackers, Chinese hackers, the whole world. But when you have a deceased relative and you want to get information, they're not going to give you any information at all, are they? Unless you have the authority, whether it be a proper probate or proper, depending on the circumstances, other type of authority, you're not going to find out if the form's missing, who the other beneficiaries are, right? It's going to sit there till you figure it out, and the only way to figure it out is to probate it if there's extra assets sitting there, correct?
Right. So another great question, complicated. So banks will vary in their protocols, but typically there are privacy rights that have to be maintained. And so people will try to elicit as much information before making a determination as to whether probate is necessary or not. Sometimes you're right, they get completely closed out, won't share anything. Right. Other times they have to present a death certificate and ask, is there a beneficiary on form? And they'll have to offer names of people, and the bank will say yes or no, but not tell you who they are.
Correct.
Very interesting. It's unfortunate. But I have things to share with people on how to avoid these little problems, but they happen every day.
Another misconception I get is, oh, I don't have to worry, I have a power of attorney. So when they pass, I have power of attorney in their account. And I recently, not only did I know that's wrong, but I had a family member who was involved in a trust, and I went with her just to help out. So she went to Bank of America and was told, no. When the decedent passes, the power of attorney passes with them. This wasn't a trust. This was assets outside the trust. And so now you have money sitting there that can't be effectuated without, again, either probate, or if it's below a threshold, there's a streamlined process, but you're not going to get that money that day. It's going to take a period of time.
Good for you, sir. Great distinction. Yet again, probably my number one misconception, power of attorney. I'm fine.
Yeah,
absolutely.
I'm good.
Right, exactly. I'm okay until all of a sudden that door is shut abruptly. And so you're right. The person expires the power of attorney, or in the absence of a power of attorney, what's called a conservatorship. That's only management on behalf of that person while they're alive. Upon passing, all of that is no longer relevant.
Right. And I had a client last year who was a conservatorship, a bunch of properties, and we sold a bunch of them, but there's one or two left, and they passed. So all of a sudden, whoa, now we go from conservatorship to a probate. It's a whole different entity. The whole thing was crazy. And the rules changed, for the different entities. So, okay, so we talked about if you have certain amount of assets, then you need to have a living trust. But there's a couple other conditions that you might need one or want one. One is making medical decisions. And that can be a whole variety of circumstances. I had one where an elderly aunt who was living with but not married to, I call him my uncle, but he's not really legally. And he had medical issues. He had some medical insurance that should have covered those issues. He was in the hospital. She went to find the insurance company. She couldn't find the bill, so she went to call the bank. But of course, She doesn't have access to the account because it's in his name, not her name. But if you have directives and such when people are incapacitated, you have the right to do that, and that's ordinarily part of an estate plan, isn't it? The medical kind of procedural authorities, things like that.
Absolutely. So we have what we generally refer to as ancillary estate planning documents. So the entire comprehensive estate plan is comprised of a multitude of documents, commonly the trust and the backup will you mentioned earlier, power of attorney we just hit on, now the advanced healthcare directive, the medical directive, the living will, common terms and colloquial exchanges with people will identify that these documents independently predetermine medical decisions that each person gets to elect on their own. And then they have agents to effectuate them should the time arrive that they're incapable of expressing themselves or making these determinations voluntarily. Imperative that we have that. Everybody needs a medical directive as well as all the other documents.
Because there's so many different decisions and preferences, whether people want to be buried or cremated can be sources of terrible family strife. I've seen just horrific arguments and families torn apart over how to handle things, how to make medical decisions, who's in charge, who's not in charge, and these things kind of it's certainly reduced dramatically. There's still mistakes and problems and such, but will dramatically reduce those decisions. So we talked about assets, we talked about medical, and the third reason that I see that people need to have a estate plan ahead of time is taking care of somebody who can't take care of themselves ahead of time, how that's to be handled. If you have children, and in fact, recently I was really strongly advising my son-in-law and daughter who had our first grandchild that, you need to get a living trust in place now because, and all the other accoutrements with it, because God forbid something happens, I don't have to go to court and have the court decide who's in charge. You want to decide that while you're alive, right? And my daughter has, my grandson has 4 grandparents. We don't want to fight over who's in charge. Just make the decision ahead of time, and we'll all play ball by that. So, is that part of the reason why people come to you? Is that family issues and secession and those kinds of things?
So glad you said that. And I tell young parents, welcome to adulthood. As soon as we have our new infant or we purchased a home, we now qualify, and you can be 22, 52, 102. Law doesn't care. You are obviously responsible, and there's that duty we mentioned earlier to protect and make decisions. I love how you frame that because I bring that concept into our discussions with people. 2 sets of grandparents, both of whom, in fairness, believe they're the best qualified parent substitute. And in turn, they will commonly lock horns in court trying to figure things out. And I tell people, you want to make your own decision relating to who you feel is best suited to care for your children.
Right.
And dispense with the controversy and conflict. It's not fair. So children, interestingly enough, could, and I underline that, could be relegated to foster care temporarily while the pendency of a guardianship proceeding is underway, especially, pardon me, if it is being challenged. So we don't want children victimized twice, bottom line.
Right. And so what you're saying is, and I've seen this, where the child is in foster care until the court decides who's in charge or court puts somebody else in charge, then the court's deciding who's in charge, which I don't know which is worse, foster care or the court deciding it. Neither is very good compared to a loving grandparent. I want to say for the record, I don't necessarily think that we'd be better grandparents than my son-in-law's parents. I think they're fine. I said to him, I don't really care. Just pick one of us so we don't have to go to court to get the approval. I just think from an expeditious point of view, why go through that? And I'm thinking it must cost $23,000, $30,000 to get guardianship put in place and be appointed. And then if you have to sell the house, then it needs court approval versus a trust could avoid all those issues. So, but again, for the record, I'm not saying that I'm better than, I'd be better. They're fine people.
But by the way,
probably better than us actually, if we had to get down to it.
Well, but Bill, just briefly, we're not going to pick on grandparents because we have siblings, right? Aunts and uncles, and other third parties, even friends, will insert themselves into a guardianship hearing and challenge based on a myriad of issues. So
Yeah.
we just don't want anyone fighting and children
Right.
being treated as pawns in a tug of war process. It's just very unpleasant.
Well, I think the thing that the average person doesn't understand is if you have one outstanding outlier child or aunt or uncle, as you would say in this case, who wants to glom on and just suck money out of the estate, they can make life miserable for everybody. And there's no shortcut. If you don't have a living trust set up and it goes to court, there's no shortcut. That person can just make everybody miserable. I've seen in LA County, I think it's a little different orange, but in LA County, for years, put sand in the gears of justice and cost tens of thousands of dollars. It's just horrifying to watch in person.
Good for you. I have a current case now where we have 8 beneficiaries, and you're right, the rule of one dissenting opinion, one problematic person is making the lives of the other 7 who are in remarkably unanimous consent to proceed reasonably and make compromises.
Right.
And here we are, just wasting yet again time and money.
Yep. And it's just that one guy, and it just takes one. It's just, and you can see our family's great. We have almost all of us are like normal, successful, wealthy, but we got this one brother. That's the guy who's gonna cause the problem because people are desperate. And when it comes to money, and you're talking typically, if real estate's involved, you're talking about big chunks of money. I've seen otherwise decent people do anything to get their chunk, and it's just I don't know, just horrifying to watch. And I think, unfortunately, now I don't mean to disparage you, but it seems like the attorneys are almost in on the grift many times. That they're both glad to keep billing and delaying and rescheduling, and everybody's getting paid, but the estate and but the poor child who's in the guardianship. It's definitely, if you ever went to court and saw it, you would walk out right away and sign up for an estate plan of some sort, I think.
Well, I'm glad you said that. And I've actually used that comment many times, and letting people know that, yes, can attorneys instigate and allow circumstances to perpetuate without question. Now, I vehemently oppose that. That goes without saying. We're trying to get to the finish line sooner. Right. But I say if we enable people to take a particular path and create problems and then compound them, absolutely. Right. So ultimately, bottom line is, how much money do people want to keep in their own pocket and the pockets of the people that matter to them, as compared to complete strangers, court systems, and other third parties? So no one envisions that for their family, but yet improper planning or no planning equates to that every day of the week.
Yep. So one of the things that one of the cores of my business is I really focus on creating value for my customers so that I can get paid what I get paid. And there are agents that charge more than me, there are agents that charge less than me. I do real well because I focus on the value I create. I don't try to be what I'm not, don't try to be less than I am. In your business, particular the estate planning, there's really a wide variety of prices, of process, of packages. How do you, what piece of that do you offer and specialize in that you feel that you create the most value for your prospective customers?
Okay.
Or clients, I guess, in your terminology.
No, of course, that's fine. So a wide variety, as mentioned, all encompassing, including attorneys. So a very important comment for people to identify is that attorneys, like physicians, generally elect to specialize in a particular area on passing the bar examination and then making a determination of the route they're going to take. So by analogy, physicians will choose a specialty area, but they will never dabble in an area outside of that particular medical specialty. Your dermatologist will never show up for an open heart surgery for any reason. Now, will we have attorneys that dabble in certain areas of law, including estate planning? Yep. Unfortunately, yes. Yep. So I share with everybody that we promote transparency and objectivity. The State Bar of California promotes attorneys to seek specialization in 11 areas under the State Bar that they've determined are more complicated than other areas. Not better, just more technically complicated in several aspects. And they promote a certified specialization So an attorney may elect to seek a certified specialization by undertaking a second separate bar exam, showing experience and educational requirements, recommendations, and so forth to meet that standard. And when a person calls the state bar and says, I have an estate planning issue or question, or a family law issue, or an immigration issue, these are some of the specialized areas of law, they direct those individuals to their list of certified specialists on the website. So I tell everyone in fairness, an attorney may purport to be an estate planning expert after 2 or 3 decades. Whether they are or are not is unimportant, but whether they have satisfied state bar criteria to qualify, I think matters. So I encourage people, whether they work with us or anyone in this arena, to choose a certified specialist off the state bar website. As far as pricing in general terms, there is an average, of course, for pricing for estate plans in Southern California. I tell people it's commonly between $2,000 and $3,000. And it depends on whether we have a married couple, a single person, how many properties, the customization and complexity. Do they have a business? Do they have pets? Do they have tax considerations? So a multitude of factors go into it. We evaluate each situation on its own merit and then make a determination. Pricing follows, like building a new kitchen, 7 cabinets, 12 cabinets, what are the materials and so on, dictates pricing. Same general idea with estate planning, A, when it's done properly, and B, when it's customized.
Yeah, I see that. Now, I'll say the reason why I do probate real estate, quite frankly, is 90% of the probate cases are handled by attorneys who've done 1 or less in the last 12 months. And so where there's an efficiency as a realtor, my customer can make some money. So I'm looking for those. The reason I wanted to meet with you today, you were referred by a good colleague of mine, Ed Garcia, but I also checked you out and I noticed that you do have the specialization on your on calbar.org. You can search an attorney and see, they're licensed and the status that they've been disciplined, and then also what the specialization is, but also your website. It's all about estate planning. And then I saw you had a YouTube channel explaining key concepts that if I have a customer that comes to you, I want them to understand what they're getting, what they're paying for, what the purpose of it is, and you explain some of those things. I think that's really important that you focus on that area, then you can go deeper in the value you give your customer. I see attorneys all the time. They specialize in bankruptcy, criminal, DUI, wills, probate, family trust, this. Like, really? I specialize in selling real estate. I could sell the Golden Gate Bridge with my license. Doesn't mean I know what the heck I'm doing with bridges. So I really admire that you do that. I think it's really important. And I think it's important for clients seeking services to focus in on a specialist who that's where they work, and presumably they're bringing more value to you, and you're able to go deeper because that's the area that you work in every day.
Very happy you said that, sir. So the educational component is by far the most fulfilling, because when people call completely uninformed on a foreign subject matter, they have questions, they want to understand. And these rules are unforgiving and complicated in their simplest form. And then ultimately, I just have no qualms when people call me as clients asking about a workers' compensation legal issue. I'm the first to say, I'm not qualified.
Right.
And Bill, I like that. I can walk into the workers' compensation court as a licensed attorney. Your example with the Golden Gate Bridge, perfect. But I would bumble around that courtroom and be a disaster. So it's a disservice. And I would like people, a common rule that we like throwing around casually is everyone stays in their lane.
Yep.
Right? I don't masquerade as the accountant. The accountant doesn't give financial advice. The financial advisor isn't offering legal opinions, and so on and so forth. So it just helps keep people protected, and that's really what we're emphasizing.
And I think, again, not to disparage an industry, but, because all industries, we can all do better, and we should all individually try to do better. I think the nature of attorneys is, as an industry, there's nobody that sounds better when they know nothing than attorneys. The best become politicians. They sound great, but they know nothing.
Right. I understand.
But and I think that the average customer doesn't understand that attorney they know, like, and trust, who did their DWI or did their incorporation or did some civil matter, and it says on the website that they do estate planning, probably knows nothing about estate planning. And Now you can't say that because they're your colleague. I can say it because I've been in the courtroom and watched the judges tear them apart. I've watched cases, not handled properly because of simple errors that the attorney didn't even know. Like in LA County, didn't know there's probate notes. How do you not know that? And take your client's fee, on a $1 million case, $23,000. How do you not know that? And the answer is that's the power of specializing is you'll know that and you'll know a lot more. So one thing I want to ask you also though is you do estate planning, avoiding probate. Do you also handle probate administration? Do you handle probate litigation, or is that part out of your lane, or is that in your lane?
Great question. We certainly do. So there are many subsets of the estate planning designation, and that, not to launch into a bunch of mumbo jumbo, but bottom line, yes. Do we do probate and trust administration every day? We do probate and trust litigation. Tragically, when people fight, we always try to come up with an amicable resolution and not really get into a trial when we can avoid it, but absolutely. And then, of course, the planning and the special considerations, special needs individuals, Medi-Cal asset protection planning, business succession planning for entities under various circumstances, conservatorships. And so we have to have an understanding about all of this, also introducing advanced tax planning. So we're looking at the estate tax exemption amount with the new president and Congress, anticipating that that may be lowered. It's hard to say. Good response by you. Hard to say exactly whether it will or won't, and whether it will change back the next term if we have a different president. Bottom line, it's a roller coaster ride. But it's still very relevant because it applies in the year that the person expires. And I have yet to meet a person who would love to pay the IRS 40% on, yes, any estate tax liability if it could otherwise be avoided. So lots of areas, and that's why I love this. It's so radically complicated, but it applies to everybody. I tell everyone, either you do it the way you want it done, or the courts are going to do it for you. Well, there's no alternative. So I love, Bill, I don't have to sell. I tell people, guys, teach and understand, and then make a determination. But I know you don't want to be here, which is the eventuality of not planning or operating under misconception, doing it yourself online. Oh boy. Or having, their uninformed or unprepared attorney try and dabble in an area that's going to unpleasantly unravel. No, we do estate planning. Oh, sorry. Last comment, sir. We do estate planning for judges and other attorneys every week.
Wow.
People are always surprised to hear that.
Wow.
And I say, guys, go back to the medical example. The cardiologist is a patient of the dermatologist.
Sure.
And will see an orthopedist when they need one. They're not going to treat themselves.
Right.
So anyway, sorry, that was long-winded, but just sharing with you a few things.
No, it's great. I think it's great. When you say the option is the estate plan or going to courts, the problem with that description is that it sounds good going to court. There's a judge, there's a big marble room, fancy furniture. So I tell them, going to court, though, to have your matters managed is like going to the DMV, but you're dead. It's about as efficient.
Good. Well, absolutely. And I would even give credit to the DMV in being better in that regard, because
yes.
Well, so here's the problem. When you at least go into the DMV, you yourself are dealing with it. Now that you've fired, you don't know who's cleaning up this enormous mess.
Exactly. You don't get to choose. You don't get to choose that. The court decides. The DMV gets to decide who runs your financial estate. No, that's definitely true. I also appreciate that you do, I saw on your website, I think, that you do probate litigation, because I think the real world of being in the conflict helps you write your documents in a way that avoids that mistake you had to litigate last week or last month or last year. And I think that when you don't do that, you're just shuffling paper, you might get out of touch with, well, what happens and will the court really allow this or not allow that? You're experiencing some of those answers in person by handling those cases, I would think.
Would you ever? So there's two sides of a fence. And ideally, you want to find yourself equally competent on both, because absolutely you have seen what ends up in the trenches, the trials and tribulations, and then you absolutely have the ability to identify these are latent considerations that may manifest themselves in the future if we're not careful. So the duality of both the transactional aspect and the litigation side of things
Right.
so imperative, so you can complement both sides.
Right. I'm similar in the sense that I represent sometimes investors buying property on court overbids in LA County Court. And then I also represent estates and attorneys listing property on the other side of that deal. And both of them make me better at the other. I think that's part of the unique thing that I do is it's a little harder work to do those two, but they both complement each other by giving me the perspective of when I'm a listing agent, how not to get taken advantage of, and I'm the buyer's agent, how to protect my buyer's interest as well. So that's kind of what I work at. Well, okay, so I appreciate the time we've had today. You've been really generous. Let's just kind of wrap up here. And I would say, I am sure that you talk to people all the time that are excited when they talk to you. Maybe it's a consult on the phone, in person. I don't know if I think you've done some webinars in the past. And they don't follow through on it, right? There's people who say they're going to get back to you and don't, and there are other people who maybe file the first part with you and don't finish the paperwork or file that. If you could say one thing to them that you think would help them see the importance of this particular area of estate planning for themselves, what's one thing you'd like to say that maybe you could say in a video that you can't say to them in person because they're not calling you back?
No, that's okay. So that does happen on occasion, and I'm certainly sympathetic. People have a misconception that there's something morbid, something macabre, something negative. They're predetermining their remaining lifespan. There's a superstition that accompanies it. I say, guys, we're talking about planning. You planned your careers, your families, your home purchase with Bill. You planned your next vacation. I guarantee you didn't just show up and say, we're flying here on the globe, let's go. So when we eliminate any sort of negativity associated with it, and just say, guys, please understand the basics. And I'm going to go back to that and reinforce it. If you don't determine, and there's always the ability to make good decisions, the people that matter most to you, the assets you've worked your entire life to acquire, and the things that need to carry forward regarding your legacy matter to every one of us. So why we would want to deprioritize something that is crucial doesn't make sense. It's always, bottom line, a lack of education or postponement. Yeah. Once they know the rules, they absolutely understand. And I have everybody in every free consultation we offer saying, wow, I didn't know that. Like you mentioned, all these great points. God, I didn't even think about that. And I say, I get it. My role is to teach you, make sense of this. And then guys, when you've created the plan, you can update it, modify it, change it. As life progresses, so will your documents. So I want to just clarify that so people are not discouraged. But in a video, guys, procrastination equals compounding problems and headaches. The eventuality is guaranteed. So just embrace it.
You can make the decision yourself now, or you can let the DMV decide for you later. Either way.
Right. That's it.
So if somebody sees this and is interested in talking to you about putting together a plan or finding out how you can support them, what's the best way for them to reach you?
So ultimately, through the telephone, we offer email inquiries, and most importantly to me, are free consultations. So we give people a 15-minute window to give them a preliminary understanding of what we're looking at and to help them understand, A, if they need help, and B, how we should consider helping them. So ultimately, they get to make their own decisions. I like your approach, which is take a look at this person, research them online, look at their reviews, look at their background, their history, their website, and get acquainted with them. Always, in my opinion, choose a certified specialist. Yes, sir. It doesn't cost a penny more. And the State Bar will emphasize that. We don't charge a penny more to be the experts in this area. And it's not a pat on the back. I say that with the utmost humility. I just want to make sure if I'm responsible and tasked with protecting people, their assets, their children, everything that's important to them, we really want the documents to work as intended. And I deal with 85+% of faulty, defective, or deficient legal documents that are out in circulation. And when people realize those numbers are so staggering, it's crucial that they update and crucial that they do it properly. They'll be gone. They won't know the difference. And now we have all these issues. So reach out to us through the website, telephone number, and we will be happy to just evaluate and go from there.
So down below in the video here, you'll have the phone number and the website set for contacting Mark and his team and setting up a free 15-minute consult. You know, I've interviewed a number of estate planning attorneys. I think that people should have a choice. You know, some people prefer male, female. Some people live in one part of the city, another part of the city. That's important to them. Styles are important. But what's critical, anybody that I'm going to talk to and recommend, is this is their specialty. This is their area of expertise, because in the long run, it might cost a little bit more, but it's going to save you a lot more in the long run. So, Mark, look, I appreciate getting a chance to meet you and your background. I appreciate your service as a policeman in Hawthorne. I don't think I ever had any personal interaction with you that I'm aware of, but I appreciate you doing what you did in Hawthorne. I've driven through Hawthorne, but I apparently didn't break any laws along the way. But I sure appreciate your time here with us today, helping people, and then hopefully we're going to get a chance to talk a little more in the future. So thank you so much.
Well, thanks for having me, sir. I appreciate it very much.